Hello, everyone, and welcome. We're glad you're able to join us today to discuss Ontario Regulation 406, the new soil regulation. I think the attendees who registered today represent a diverse bunch of clients and stakeholders, which speaks to the broad effect that this regulation has across a variety of sectors. My name is Carla Reynolds, and I just want to give you all a quick overview of Zoom for those who might not be familiar before we actually get started. Everyone will have access to 3 tools, and you should see graphics for these along the bottom of your screen. The chat tool, first of all, for today's session, we will only be using this tool if you are experiencing any sort of technical difficulty or have a Zoom-related question. We have a Pinchin team member on the call today who is going to monitor the chat and who will respond to each of you if you're having any issues. The raising a hand tool, this is the second tool. I'm going to ask everyone right now to raise their hand just to confirm that your audio is all working properly and you can all hear me. Okay, great. The third tool is the Q&A. This is where we're going to be using all presentation related questions about excess soils. So we're going to be monitoring the session throughout the webinar. And if a number of people have the same question, we'll stop and address the question right then and there. Otherwise, we'll wait till the end and we'll do a Q&A session at the end of the session. It's about 45 minutes long, and we've reserved about 15 minutes for a discussion at the end. It says polling there, but we're not using that feature today. At the end, there will be a feedback survey. So we are just hoping you please take the time for that and let us know what you thought about the webinar. And if you have any thoughts on other presentations you'd like us to provide for you, there's a place for that at the end. The presentation is being recorded today, and it will be available on our website later on, probably in about 2 or 3 days. You can go to there and refer to it and revisit anything that you wanted to. So let's get started with the presentation. This is a little bit of an introduction about Pinchin. As you see, 42 offices across Canada. I should probably mention that of those, 18 are in Ontario. So we do have really good representation with local offices across the province and are able to deal with your excess soils related questions and issues and projects from any of those offices. So today's presenters, I mentioned, I'm Carla Reynolds. I'm the operations manager at Pinchin's Markham office. And with me today and running through the presentation is Christian Tenaglia. He's the Director of Environmental Due Diligence and Remediation from our Northeastern region.
Awesome, thanks, okay. Carla. Welcome everybody, and please, at any point in time, if you have questions that are topical about maybe some of the slides that we're discussing today, use that Q&A function to sort of either raise your hand or type in a question that might be relevant. And if so, Carla can just kind of stop me while I'm presenting, and we can have a little bit of discussion about your question, or we can save it to the end and have a little bit of a broader discussion about that topic as well. For today's presentation, here's our agenda. We'll talk a little bit about what this new regulation is, and certainly what types of projects it applies to. And as Carla mentioned as well, our clients that are on this presentation and webinar are of a diverse nature. So how this regulation affects you and your business may vary significantly. So we'll do our best to sort of interpret the significant features of the regulation and what it means to your business. And certainly we'll talk about the phase-in period of Reg 406, what we need to be doing right now to comply, and what we need to be doing in the future to comply, because both of those are a little bit different. And then we'll sort of just recap on the business side of things, just to talk a little bit more about due diligence and what we need to be doing to maintain that compliance and the overall impact to our projects. So Ontario Regulation 406/19 was first filed in the EBR as of December 4th of 2019. Because of COVID and the pandemic, it was originally supposed to be started off as of July 1st of 2020, but the pandemic delayed that first phase to be as of January 1st of 2021. So right now, this regulation is in effect, and we'll talk about what that first phase means in order to comply. Before we get started into some of the technical aspects, I just wanted to share with everybody this one slide about the rationale that the Ministry of Environment, Conservation and Parks has used for the development of the new regulation. And I think first and foremost, I've sort of prioritized these and what I think the ministry's priority levels were in developing the new reg. But first and foremost, the intent here was to really start curbing some of that illegal dumping or inappropriate relocation of excess soils. And what I mean by that is maybe some of the moderately contaminated material or excess soils that we don't know what the quality is, being relocated to green spaces or parklands or agricultural sites that maybe can't receive that quality of material. So the intent here was really to sort of stop that from happening and maintain a certain level of compliance within the province of Ontario to make sure that, contaminated material goes to a landfill and clean soils are classified as clean and are used appropriately. Secondly, I think it's important to recognize as well the intent here to manage how much clean soil is being brought to landfills. I think it's important to understand that all of our landfills in Ontario, have capacity requirements that they have to meet. And to try to minimize the amount of clean soils is important in terms of maintaining lifespan for landfills. So decreasing the amount of clean soil going to landfills is definitely an important aspect of Reg 406 as well. Thirdly, fourth, and fifth, by managing excess soils in a more appropriate way or determining better reuse of soils will overall have a decrease in transportation of that excess soil. And, through that decrease in transportation, we will see or should see an overall reduction in greenhouse gas emissions from excessive transportation. We should see also a decrease in, excessive road damage because of all that extra transportation. And with that being said, we should see that decrease as well in transportation and landfilling costs of clean excess soils. So this slide here is relatively important. We prepared it based on the regulatory phasing periods of Reg 406. You can see here that that top line says reuse rules and waste clarification. And I'll talk about the details of what those compliance requirements are, but they are technically in effect as of January 1st of 2021. The excess soil planning requirements will be in force as of January 1st, 2022. Those excess soil planning requirements are fairly substantial and will require a lot of planning and understanding as to how they sort of are incorporated into your project going into the future. So I'll go into what some of those excess soil planning requirements are in a lot more detail as we get later on into the presentation. But these two phases are the most important. What we need to understand to do right now is January 1st, 2021 is ensuring that we're moving excess soils in a clean and appropriate way. And then come 2022 is when the administrative components of Reg 406 are in effect, which really are those planning documents and all the planning requirements. That next phase as of January 1st of 2025 is when they're going to enforce a restriction on landfilling of clean soils at our municipal landfills. That does not necessarily preclude landfills to receive excess soils or clean soils for cover operations and operational issues such as capping. So there are caveats in the regulation that allow for landfills beyond 2025 to receive excess soils for rehabilitation purposes. but there will be a restriction as of 2025 on receiving clean soil at a landfill for simple disposal. One last thing here to note of rather importance, the ministry is allowed for a grandfathering period of the excess soil planning requirements. So if there are the opportunity to engage in a project and get it under contract before January 1st of 2022, that will allow for certain exemptions, particularly towards excess soil planning requirements. So I think the main part here, the main point of the reg is to really, and how we manage our compliance with the regulation is understanding through some of the definitions of the reg, how it applies to our projects. This first bullet here is sort of an excerpt from the definition of the word project in the regulation, and it's how we sort of determine whether or not that may or may not trigger the reg on our site or one of the projects you may be involved in. So what is defined as a project is any form of development or site alteration or the construction, reconstruction, erecting or replacement of a building or a structure on a property, or the establishment, replacement, alteration, or extension of infrastructure. Those first three bullets are significantly broad, and they have been written up in such a way where it can capture just about any type of construction project that might be out there in normal business. So we have to sort of keep that in mind when we're looking at what we're planning on doing on a property, and sort of reference back to that description to ensure whether or not the reg captures what we're up to. And then lastly, if you have a project that involves the removal of any liquid soils, such as dredging activities in a waterway, or any kind of sediment removal from things like stormwater management ponds or other surface types of surface water bodies, that material that you're removing from those projects will also be treated as excess soil. And then secondly, we want to understand, what a project area is. So we understand what type of what projects will be included in the regulation, but we need to understand when the reg triggers, soil movement, and we look at that through the definition of a project area. So the definition of a project area is a single property or adjoining properties on which that quote unquote project is being carried out. So as soon as soil leaves the project area, meaning that it leaves that property boundary, that is when the regulation is triggered. So moving soil from property A to property B. This next slide sort of goes a little bit deeper into what types of projects will be triggered under Reg 406. And certainly, and first and foremost, are projects dealing with clean and reusable soil. So we really need to understand what that definition is of clean and reusable, and the difference between clean excess soil versus what would be considered as waste. So any type of material that is contaminated or has other waste materials in it, such as asphalt, concrete, building materials, that type of material is not defined as clean reusable soil and would be defined as waste and needs to be treated in accordance with Reg 347 and wouldn't fall necessarily under this type of project. There are also other there's also a couple volume limits and triggers within the regulation that should be sort of understood as far as understanding how your projects are treated in accordance with Reg 406. One of them being the 350 cubic meter volume limit, which is what we use to sort of characterize the quality of soil. And then there's the exemption under Schedule 2 of the total volume being hauled off of a site where, at a certain point, depending on the type of project, if you're under 2,000 cubic meters, there may be some exemptions as well from the planning requirements. So really understanding those volume triggers is important so that we can apply the right process in treating the soil. There is also a fairly strong link to what you guys may be already familiar with Ontario Regulation 15304, which is our records of site condition regulation. And in that regulation, and this regulation as well, we have that definition of what's called an enhanced investigation area or site. these properties would be considered to be gas stations, dry cleaners, or any other type of industrial use. And those descriptions of properties are in Reg 153. That determination, if your property is an enhanced investigation site, will trigger all of the planning requirements under the regulation, Reg 406. So we need to be aware of what the land use is on a property. And certainly if your property is a residential, institutional, park land use, we end up treating those types of land uses a little bit differently as well under Reg 406. So it's very important that we take a look at the land use and not the zoning. We take a look at the land use to really interpret how the reg affects your development project. Okay. Now, if your work, if your excess soil movement project is being completed for the purpose of soil remediation, it's also important to note that if it is being done for soil remediation, the reg applies. So we have to treat that excess soil a certain way as well. And furthermore, any kind of large infrastructure project involving the relocation of excess soil, and those types of projects could include highway reconstruction, sewage system installations, large electrical distribution projects or telecommunication lines, bridge reconstruction projects, etc. Those types of projects can be treated a little bit differently as well if they're being completed by a project leader or a public body where they are relocating excess soil to another one of their projects. So there's some tricky exemptions in here related to these types of projects that we need to be highly aware of. So land use and soil quality are extremely important when we're looking at excess soil and how we relocate it. So who's responsible for compliance with this regulation? The ministry also gives us the definition in the regulation of a project leader, which means anybody or any person or proponent who is ultimately responsible for making decisions relating to the planning and implementation of that project. So it's the highest level of person on the project, and that'll usually go all the way up to the property owner, who is ultimately responsible for directing the work. There's been a lot of discussion lately about the ability for project leaders to extend that responsibility of compliance with Reg 406 to a third party or a contractor. Obviously, this regulation is brand new. How that responsibility can be contractually transferred to another party is a little bit unknown yet. But it's highly recommended that that project leader, if you are the property owner or the developer, you take full accountability for compliance with Reg 406, and not trust that you can transfer that liability to a third party, because it's more important that, if there were to be something that happens as a result of an excess soil movement, you want to be responsible for it, and you want to know that it's happening and treat it accordingly so that we can comply with the reg. Furthermore, when we're looking at projects and when we're talking about, excess soil movement or soil quality characterization, making sure that it's clean, we need to have what's called a qualified person to be able to help characterize that and sign off on the quality of soil being relocated. A qualified person is the same definition as a qualified person under Reg 15304, which is an engineer or a professional geoscientist. That person, that QP, plays an important role not just at the soil quality characterization stage on a project, but also at the receiving side and sort of all throughout the project cradle to grave. And I'll explain that in a bit as well. So I mentioned before in a previous slide, we need to ensure that the soil is being treated as, clean, excess soil, make sure the quality is suitable for reuse, and anything that is waste needs to be treated in accordance with Reg 347 and taken to an approved disposal site. When we're looking at the regulation and how it defines what we need to do to designate something as waste or not waste, we have to meet all of these following requirements. So excess soil needs to be transported, first off, directly to what's called a reuse site, a Class 1 soil management facility, or a Class 2, or a waste transfer facility. And I'll talk about each one of those in a little bit more in detail. Soil also has to be confirmed that the quality is clean and that it's not contaminated, like I mentioned. And excess soil needs to be deemed as being dry. How do you determine if something is dry? We refer back to OREG 347, and the determination of dry or solid is made through the process of completing a test. Liquid soil is obviously something that is being excavated from the ground surface that is, probably within the aquifer or extremely wet for whatever reason. It needs to be dewatered first and needs to be made sure that it's solid and dry before it's transported from a property to another property. And then this fourth bullet here is extremely important. That soil quality and quantity need to meet the criteria of the reuse site. And the reuse site can be a number of different things. We'll talk about that in a bit, but some of them may have things like bylaw provisions, certificates of property use because it has a record of site condition filed for it, or there may be municipal planning requirements for reusing excess soil, or that reuse site may also have a permit in place for it to receive excess soil, such as an aggregate pit. Those terms and conditions in those permits, approvals, or bylaws need to be met for the reuse site. So the quality and the quantity need to meet the criteria of the reuse site. That reuse site must also provide written consent now that they are acknowledging the quality of the soil that they're receiving and when it's being received. So what is a reuse site? A reuse site is a property which excess soil is used for a beneficial purpose and does not include a waste disposal site. The primary use of a reuse site must not be for the deposit of excess soil. We cannot be taking clean excess soil to quote unquote like a soil dump or a clean property for the sole purpose of getting rid of the soil. It needs to be brought to a reuse site for a beneficial purpose, which is backfilling of an excavation for development, or final grading, or achieving a necessary grade for development, or for site rehabilitation. Those first two bullets there, backfilling an excavation and final grading purposes, are fairly obvious, and that makes a lot of sense for a beneficial purpose. That last one there, site rehabilitation, there's a lot of maybe industrial properties or aggregate pits or landfills that may need clean soil for environmental rehabilitation type projects, where that clean soil can be used for a beneficial purpose in order to rehabilitate the environment. For example, capping of a landfill, or reinstating the environmental condition of a depleted aggregate pit. So there are some site rehabilitation type uses for excess soil as well that we need to be aware of. Thirdly, quantity cannot exceed the beneficial purpose of the reuse site. So if you're backfilling an excavation and you need 1,000 cubic meters of soil to backfill that excavation, you cannot take 2,000 cubic meters. It's got to meet the quantity for the beneficial purpose of the reuse site as well. And fourthly, that soil must be placed within 2 years in accordance with the soil rules. The soil rules book is an extra document provided to us through the regulation that gives us some soil management activity parameters. If you're not taking soil to a reuse site, you can take soil to what's called a Class 1 soil management site or a Class 2 soil management site. A Class 1 is either a soil bank storage site or a soil processing site. A soil bank storage site is a property where excess soil is managed on a temporary basis and is operated by a third party. So it could be an independent, commercial business owner, and what they've set up, this Class 1 site, but will more or less be a receiver for excess soil from multiple projects until it can be used for final placement at another reuse site. So in other terms, a Class 1 soil management site might be also referred to as maybe a soil recycling center, where clean soil can be tested, grouped, processed in whatever way, treated, and be bulked up, categorized, and reused at another site. A Class 2 soil management site is a little bit different. It operates the same way as a class 1. It's an independent piece of property where excess soil is being managed on a temporary basis, but that facility or that property that's off the project area is owned or operated by a public body or the project leader from which the excess soil was excavated from. So if you have a small footprint on a property, you're a developer, for example, and you need to relocate a large volume of excess soil in order to keep your development and construction activities going ahead, but you have nowhere on site to store it, you can move that soil to another one of your properties, establish that class 2 soil management site, and then relocate that soil back to your site afterwards. Okay, so that would be sort of a temporary facility that you own and operate on your own property. I put together the next 2 slides just to kind of recap everything that I've been talking about. And this first one here is sort of the 2021 sort of requirements. Just a little bit of a flow through of how we interpret Reg 406 for the next 7-8 months. And we look at, again, just understanding that definition of what a project is: development and site alteration, building construction, infrastructure projects, and sediment removal. And if it is a project, if it falls within this description here, we need to understand whether or not that soil is waste or not waste. Is it clean material? Or if it's not, if it's waste, it needs to be treated in accordance with Reg 347, and therefore this Reg 406 would no longer be applicable. If it is clean material and it is not deemed as being waste, we need to understand, well, is it leaving the project area? Is it leaving our site? If it's not and is staying on site, then the reg is not applicable. If it is leaving our property, then we have to characterize the soil quality based on its quantity and ensure that the quality of the soil leaving our property meets the excess soil standards for the reuse site so that it can be reused. This is sort of our generic flow chart of interpreting how the reg is triggered right now on our current projects. Next year, the only difference really is once we determine that we have, soil that is not waste and is leaving the project area, we have to go through the planning requirements when the reg is being triggered, which includes a number of documents and a number of steps to ensure that we are in compliance, such as an assessment of past use report, a formal sampling and analysis plan, soil characterization, excess soil destination reporting, and then there's going to be a tracking system and a QP declaration requirement. Once all that is completed, then we can proceed with relocating that soil to a reuse site. And then I also wanted to share this illustration with you as well to sort of give a good understanding of what the QP's sort of involvement is throughout the project. This is just sort of, the project site, the project leader, they have a responsibility to ensure compliance with the reg. And when the soil is relocated from their property, it's going to be, obviously treated on site first. It's going to be characterized on site first. And then that QP's involvement is going to be on site. It's also going to be off site at the reuse site. And this QP, this consultant or engineer, may be different from site to site to site. It doesn't always have to be the same QP, responsible for understanding, the quality of soil at the project area as well as the reuse site. This can be a number of different consultants, and we'll all be working together to ensure compliance with the regulation. But a QP in the regulation is required to ensure that the quality at the project area is met, and a QP is required at the reuse site as well to ensure what they're receiving meets the excess soil reuse standards of their property. I'd like to point out as well that if we're dealing with facilities that are class 1 or class 2 soil management sites, or you have a waste transfer facility, these types of facilities are operating under an environmental compliance approval in accordance with the Ministry of Environment. So in order to obtain one of these types of approvals and operate as basically a waste receiver, you will have some QP requirements as well to ensure that the quality of soil being received at these facilities is of a certain type in order to ensure that where it goes afterwards meets the excess soil reuse standards as well. I kind of drew in this dashed line and sort of link in, the contractors and the consultants that are going to be involved with the project leader, and their oversight really, should be supported by a QP in order to ensure that the hauling, characterization of the soil, where it's going, is all sort of in compliance with Reg 406. So back to our phase-in period here. I just want to kind of highlight, this is the first phase that we are required to comply with right now, the reuse rules and the waste clarification requirements. And I'll go into a little bit of details as to what we need to be doing from now until December 31st, and then going forward into 2022 when all of the planning requirements come into effect. So the first thing we have to be extremely aware of, like I already mentioned before, is understanding what that clear waste designation requirement is. How do we ensure that the soil quality that we're moving from our property is clean, right? And is it being relocated in accordance with the reg? So excess soil may be reused and is not considered waste if it is being beneficially reused. And we kind of covered that already. It's going to be being used to backfill an excavation or bringing a property up to grade or for rehabilitation purposes. And then we have to ensure that the quality and the quantity of the soil being excavated from property A aligns with the beneficial reuse of our reuse site. And we have to ensure that that soil quality is dry. I also mentioned this before as well, that reuse site needs to consent in writing that they are receiving the soil. That is a legal requirement as of January 1st of this year. This slide here, some of you may know a lot about the Ministry of Environment site condition standards, and I kind of, alluded to one of our volumetric triggers in the regulation that anything, below 350 cubic meters, we can apply our generic site condition standards to that soil quality, tables 1 through table 9. But when we have soil volume movements exceeding 350 cubic meters, we have what's been given to us by the Ministry of Environment, our tables 2.1 through 9.1, which are our excess soil standards. Some of them are actually more stringent than our generic site condition standards, so we need to be really aware of what those contaminant levels are on our properties to ensure that they are meeting our excess soil standards. Furthermore, when we're looking at larger volumes of soil being relocated from property A to property B, that there could be leachate testing requirements as well that we need to be aware of. Also, what we need to be aware of is the verbal hauling requirements that are in accordance with the reg as of January 1st. If a hauler was moving excess soils at this point in time, they could be requested by the Ministry of Environment to be to furnish information about the quality of the soil being moved and where it's being relocated to. So we do have a verbal hauling requirement as of 2021. Come 2022, things are going to change a little bit, and we'll be moving towards an electronic or hard copy hauling record requirement. And some of the information that's going to have to be provided to the ministry if you were to be stopped as a hauler would be the location, the date and time of the excess soil that was loaded for transportation, the quantity and quality of the excess soil in the load, the name and contact details for the person that can be contacted for any information needed about that load and the soil quality, and certainly the name of the hauler, the driver, and a license plate of each load, and the location of where that soil is being deposited. So let's fast forward to January 1st of 2022, and what do we have to do to meet the excess soil planning requirements? First off, before a project gets started, we'll have to complete what's called an assessment of past use report. So if anybody's sort of familiar with the environmental consulting world, we need to look at a property's historical land use and determine what those areas of potential environmental concern are. Things that would be considered as apex might be things like gas stations, underground storage tanks, fill of unknown quality, etc. There's a number of different things that could trigger what would be considered to be an APEC. So we do that assessment of past use report, which could come in the form of maybe a phase 1 in accordance with Reg 153, or the ministry under Reg 406 gives us a framework for that assessment of past use report. So that is pre-prescribed for us in the soil rules book. Once we have that assessment of past use report complete, we develop what's called a sampling and analysis plan to go to the site, look at where the excess soil is being generated from, and collect enough samples to meet the minimum sampling requirements under the reg, obtain that soil data, and then prepare that soil characterization report. That soil characterization report will tell us basically the soil quality being excavated from that project area. That quality will help us determine where that excess soil can be relocated to. Once we understand the soil quality, we can complete then the last formal document, which is that excess soil destination report. And that'll help us characterize, okay, well, we have this type of soil quality leaving property A, we have property B, and we kind of connect the dot and we say, okay, the soil quality from A can meet the soil quality requirements for property B. So all 4 of those documents are required when your project is triggering the reg. Also, what we're going to have to do come 2022 is implement a tracking and registration system. That registration system, unfortunately, we have not been shared what that looks like yet. The ministry hasn't released it, so we don't know what it looks like. But it will be like an online portal of some sort where we can upload and register a site. And the tracking system of the excess soil movement will be up to the project leader to determine how that's done. Like I mentioned before, soil movement will have to be tracked either by electronic format or by a written format. We'll have to keep a good record of all the soil movement activities. Those hauling records may also require large reuse site registration. So if a large reuse site is receiving a number of deliveries from a whole bunch of different projects, there may be a requirement as well to have that site registered, and hauling records will be required for that receiver. So what are some of the exemptions that are in the regulation that we need to know about? And some of them are very operational and apply to things like utility companies or municipalities. But first off, really small quantities, anything less than 100 cubic meters of soil can be still moved to a landfill without any kind of testing, soil characterization. That is probably our smallest quantity exemption to exclude those planning requirements. So if you're under 100 cubic meters and you're taking it right to the landfill, that will not trigger the planning requirements in the reg. In addition, if there is an emergency, for example, maybe a road washed out, or there's a landslide of some sort, and it's posing a danger to health, safety, or the environment, removal of that soil due to emergencies will also not trigger the planning requirements. Projects that are related to maintaining infrastructure in a fit state of repair, for example, in the winter months when we have frozen water mains and we have water main breaks, those types of utility operations will also be exempt from the regulation and the planning requirements as well. The last 2 types of exemptions are unique. This one here, that if you are dealing with topsoil and is being reused as topsoil and it's not coming from one of those enhanced investigation project areas and it's not being taken out of a project that's being done for remediation, that topsoil as well does not have to undergo all of the planning requirements. This last exemption is fairly important, and I think it will apply to a lot of our projects that we're going to be dealing with. So if you have a project like a construction project and you're moving soil, it's not coming from an enhanced investigation project area, not from remediation, and that overall volume is less than 2,000 cubic meters. And I mentioned that volumetric trigger in one of my previous slides. That really is one of the key exemptions that we need to be aware of. So if you're under that volume and it's a low risk type of construction project, you're not, like I said, you're not in an enhanced investigation area, so you're not an industrial site or a dry cleaner or a gas station type project, or if there's no apex, and you're not, moving soil for remediation purposes, then you may be exempt as well from the planning requirements. Now, those key exemptions, you can look in the reg yourself, and you can actually read through Schedule 2. It's a brief list, but those exemptions allow you to be exempt from what's called Section 8 of the reg, which is all of those planning requirements, the assessment of past use report, the sampling and analysis plan, the soil characterization report, and the excess soil destination report, but it does not exempt you from the entire regulation. We still need to follow all of the other components of the reg. For example, we need to ensure that we're still moving soil in accordance with the soil rules and the reuse rules. We have to ensure that the excess soil reuse standards are being applied for testing of the soil and ensuring the quality meets the reuse site, and clearing that waste designation, making sure that the soil being relocated to another property is not considered as waste. Okay. And then just to kind of wrap things up here, I put in here a few things to consider as we sort of transition into adopting the regulation. Right now, we're seeing everybody in the industry sort of adjusting to having to comply with the regulation. And I feel that this year, the ministry has sort of given us this, the next year to sort of understand what those planning requirements are and how they fit into the overall planning and logistics of a project. And we'll need to sort of adopt all that and sort of transition into 2022 when those planning requirements are going to be in effect, and make sure that excess soil requirements are being taken care of earlier and earlier in our project stage to ensure that there are no hiccups along the way or delays in your project. We don't want those delays to sort of cause an issue in your project. So understanding the planning and logistics of executing the compliance side of Reg 406 early on in your project is of great importance. And it is one thing for our project leaders to understand what their requirements are, but it's also important for the haulers on your project to understand what they have to do to comply. So hauling, delivery, and all that tracking of excess soil will be a component that they'll be required to fulfill as well. This bullet here, Class 1 and Class 2 soil management sites, my experience and Carla's experience and Pinchin's experience is that there have not been a lot of these types of facilities developed in Ontario yet. Like I mentioned before, a Class 1 site, if you are going to be one of these, soil recyclers or a third-party soil handler, you will have to obtain an approval with the Ministry of Environment to operate one of these facilities, a Class 1 facility. That approval process is probably about a 6-month window, depending on your site and your application with the ministry, its completedness. So in order to understand what these Class 1 sites are, how they operate, is a little bit of an unknown yet. So we'll have to see how those facilities develop and how they operate to sort of understand how well they integrate into the whole excess soil world. The Ministry of Environment Enforcement and Support is a little bit of an unknown as well. We were told back in January that we were supposed to be getting some supporting documents and guidance material on how to comply with the reg. We haven't seen it yet from the ministry. We've had lots of good communication with the ministry, and they're giving us lots of support and guidance on interpreting the reg and how it comply or how it affects our projects. But there hasn't been a whole lot of written communication out from the ministry yet, nor do we really understand how they're going to be out and enforcing the reg. So that's sort of a to be determined, something to be aware of. I mentioned as well, project leader liability. If you are a project leader or maybe for example, a municipality, understanding how we deal with liability is very important. You do not want to be, you do not want to be call it in the news for being involved in a project where excess soils from your property was not treated in accordance with the reg and relocated to a clean property, and lo and behold, they find contamination. You do not want to sort of be involved in that sort of that type of project. So I really encourage everybody to understand sort of the technical requirements of the reg and understand how we can kind of minimize that from happening. How much you extend that liability to say another third-party consultant or a contractor is yet to be tested. But I would recommend the wording in the regulation is very clear. A project leader is ultimately responsible for all the decisions on a project. So you are ultimately responsible for compliance with the reg, no matter how you write that up in a contract. Also, we have to look at our partners, our stakeholders in the community, so landfills, and understanding how we can use those to our benefit. We're looking at some of those landfills and we're looking at their cover and operational needs. So there may be an opportunity to work with your local municipality by providing them excess soil to use for rehabilitation purposes. So that's something to really be aware of, and understanding too in 2025 that we cannot just be taking soil to a landfill for simple disposal. And understanding what that beneficial use really is. Like I mentioned before, backfilling an excavation or bringing a property up to grade. That's really, really important to understand that we cannot be bringing soil just to a property for simple soil relocation and disposal. It needs to be brought there for an actual beneficial use. And lastly, environmentally sensitive areas. Your contractor or yourself may be relocating soil from property A to property B. If you test your soil on one site and you have good soil quality, but that data may not necessarily meet the property where you're relocating your soil to. You may or may not know that in Ontario we have different standards for more environmentally sensitive areas. So if you're dealing with a reuse site or a property where you want to take soil to, that could be maybe a waterfront property or a shallow soil property, or maybe it's got a wetland on the property or something along those lines that drive its sensitivity up, your soil data may not necessarily meet the reuse site standards. Okay, so that's very, very important to understand that you may think you have clean soil, and it is probably clean, but it may not necessarily meet the site's reuse standards. So something to be very aware of as we transition soil relocation to a more sensitive use. Some potential issues that we've talked about as a group here at Pinchin that we should all be aware of. How do we find reuse sites on the market? Right now there is no catalog or available database of reuse sites out there that's being widely used. So understanding how contractors and how are we in the environmental industry going to identify where these reuse sites are, and what can we do to be better informed as to where we can relocate soil to. So that's going to be a challenge as we go through this transition into 406. Also, what do we do when we identify contaminants in fill material that we thought was clean? So right now, some of the testing requirements for excess soils are fairly significant. We may have what we thought was a clean property, and when we go and collect all these samples of soil that's going to be for relocation purposes, we may identify contaminants in soil that are above those reuse standards. So what are we going to do with it, right? And how do we react to that? So we'll have to come up with appropriate remedial plans to deal with contaminants in fill material when we find them. And thirdly, which is probably very important to everybody here, is how will the impact of Reg 406 compliance affect the overall cost of projects? Like I mentioned before, if it falls within the reg, we're going to have to deal with assessment of past use reports, sampling and analysis plans, soil characterization and testing, and obviously the destination issues as well. So looking at the big picture, the overall cost of compliance with Reg 406 will be something that'll have to be factored into your budget and factored into your overall project. Contractors and haulers, consultants and receivers need to be clear when they're incorporating Reg 406 compliance wording into contracts. What you have, like I mentioned before, trying to extend that liability to, say, a contractor, a hauler, or a consultant may be difficult. The wording in your contracts must be fairly clear as to what the expectations are in accordance with Reg 406. So I strongly recommend you maybe when you're writing up those contracts or agreements with contractors and haulers, that you maybe have a lawyer look at them to ensure, and a lawyer that's familiar with Reg 406 to ensure that the wording is compliant. What do we need to do to document and ensure we are considered under the grandfathering provision? That's very important as well. Like I mentioned before in one of our initial slides is that we have until the end of this year to ensure that our projects fall within the grandfathering provision. What kind of paperwork do we need to do to ensure that that project is exempt from the planning requirements going forward, and take advantage of that grandfathering provision? That's something also that should be reviewed by a lawyer to ensure that we can capture that period of time. And then finally, one probably major issue that we're dealing with right now is what is being done for small quantities of soil and what's being done for due diligence purposes. If your project in your excess soil movement project does not necessarily capture or fall within the all the planning requirements and trigger the full effect of the reg, we still need to ensure that the excess soil being relocated is meeting that clear waste designation. So what are we doing for small quantities, low risk projects to ensure that the quality of soil is being relocated to another site safely in compliance with the excess soil reuse standards, and being done so in a practical way so it doesn't encumber the project further. So just that last one there, I think is fairly important to ensure that we're doing everything we can to keep you guys and our clients out of trouble in accordance with the reg, but also to minimize any kind of contaminants leaving your site from a due diligence perspective, and not allow you guys to be in a position where inappropriate relocation of soil was deposited on another property. And those types of things can transition into a significant form of liability for you. So we don't want that to happen. So what can we do now to ensure that soil quality leaving your site meets our reuse standards? And that's probably one of the main things that we're trying to deal with right now, and without that affecting the sort of flow of a project right now. We want to be able to give you guys the best consulting needed to make sure that basically the soil is clean. So that's the end of the presentation, guys. I wanted to sort of open this up to any questions that you may have about excess soils, in particular, any kind of projects that you might have, or how the reg applies, or any kind of wording in the regulation that may affect some of the decisions that you're making right now to ensure compliance with the reg.
Yeah, we had some really good questions come up on the Q&A. Christian, if we can sort of make our way through some of those.
Sure.
The first one was on grandfathering of contracts. If a contract is entered into before January 1st, 2022, is it correct that on January 1st, 2026, projects under such contracts that have not been completed by that date are then subject to the filing requirements?
That is correct. That's my interpretation as well. So anything beyond, if your project that you sign under contract now isn't completed by 26, you'll be required to comply with the reg.
The second question, does asphalt grindings meet the definition of soil?
No, but that's a good question. Asphalt grindings is definitely not the definition of soil. If you look in the regulation, there is a very specific definition of what soil is. It's the same definition that you'll find in Reg 153 as well. It's soil is actually defined as a natural mineral, and it's got a particle size associated with it. So, asphalt grindings definitely is not considered to be excess soil. That would have to be treated with probably, maybe more in line with Reg 347, either as a waste product or treated as, maybe a recyclable material where it goes to an asphalt recycler.
For a Class 2 soil management site, can an employee of the public body act as the QP, or would this be considered a conflict of interest?
I think the reg allows for QPs of the public body to oversee the soil movement activities. I believe there is flexibility there, and you will not have to retain a third party in that regard.
If we have assessed a site previously, are we grandfathered from the planning requirements if the soil is being relocated from the site after January 1st, if we have a development contract in place?
If you have a development contract in place And if you have a development contract in place, then you should be grandfathered in from the planning requirements. So you may already have some environmental work done on your project. It could be a phase 1, a phase 2. Again, just because you're exempt from the planning requirements doesn't exempt you from all of the other requirements of the regs. So you'd still have to ensure that the soil quality being moved is being done so in accordance with the soil rules or the reuse site standards and excess soil standards. Hopefully that answered the question.
What is the applicability of the regulation if soil is coming from a federal site?
That's a really good question as well. If soils are coming from a federal site and they're going to a non-federal site, provincial or wherever, and I had this very similar question with respect to Indigenous communities and First Nation lands. So if you have excess soil being generated from a federal site, but going to maybe a provincial site or a municipal site, I would think then that the regulation would be triggered because it is sort of capturing non-federal lands. I would recommend, though, just because it is on a federal site, that we, and I don't believe that there are any kind of federal rules or regulations associated with excess soils. My advice would be to use the excess soil Reg 406 as a little bit of a guideline to deal with excess soils on a federal site. It's a little bit of maybe a conservative approach, but I think it would be appropriate to ensure that we have a high level of due diligence to ensure excess soil movements on federal lands are being taken care of in the same way.
Is there any support for sourcing a nearby reuse site, such as a database, or are the project leaders up to? Is it up to the project leader to find eligible sites on their own?
Great question as well. Right now, to my knowledge, I have heard sort of out there that there may be groups getting together trying to develop this sort of reuse site database for proponents and developers to look at and use as a library or just a contact list for identifying where these reuse sites can be, have soil brought to. To my knowledge, there is no formal registration location for these reuse sites. That onus is on the project leader to find a reuse site for the excess soil.
You mentioned that the 2,000 cubic meter exemption would only apply if no apex are identified. If the only APEC identified is related to the application of de-icing salt, could the site still be exempt from filing a notice on the registry or exempt from the planning requirements, assuming it meets all other criteria?
Great question as well. Salting activities, winter maintenance activities could affect the soil quality to a degree where it may not meet the reuse site standards. I would recommend that just because the only APEC on a site is winter application, you may want to look at whether or not the reuse site can receive, first off, salt contaminated soils. I don't know if that single APEC would preclude or exempt all of the like section 8 through 12 planning requirements. I would think that an APEC, no matter what, whether it's salting or not salting, would sort of trigger the full effect of the regulation. So I wouldn't want to say that that type of activity would be precluded. If we do have salt contaminated soils, the regulation does allow for certain flexibility in how we relocate them and put them and reuse them at a reuse site. But I wouldn't necessarily think that would preclude you from all the planning requirements.
If there's historic reporting that indicates the soil does not meet reuse criteria and must be sent to landfill, is the excess soil immediately classified as a waste?
No, I mean, historical documents can be a little bit challenging, right? The way we look at them, from a consultant's perspective or a QP's perspective, and is really dependent on age. right? Like some of these historical documents could be, 5 years, 10 years old, and they may not really be representative of the current soil quality. So we have to be aware of that. Furthermore, they may not necessarily fully categorize or qualify the total amount of excess soil. So those excess soil, those historical reports could be, for example, maybe an old phase 2 report that may not really capture the full area that excess soil is being generated from. So I wouldn't want to say that historical document is good enough for excess soil characterization. And I think that's where some of the due diligence requirements come in. Having a QP look at those historical documents and looking at the total area that excess soil is being generated from is really important to ensure that we're capturing enough data to characterize that excess soil for an appropriate movement from the property. There may be other apex there that are not being taken into consideration. Maybe some of the historical sampling activities that were done in those reports may not meet today's standards, et cetera there. So there's a lot to look into with historical reports. And I wouldn't necessarily hang my hat on all those historical reports because I think they they're very site specific and they're age specific. So I think that they would have to be fully reviewed first before making that determination. With that being said, though, I think that there is an opportunity to use some of those historical reports to our advantage. And some of these projects may be very specific in a way where that phase 2 report or that historical report gives a lot of information about the excess soil quality. So we could use some of that to our advantage.
Would a township issuing a fill or site alteration permit be considered a project leader?
No, I don't think so. Just because you're a township issuing a permit doesn't necessarily make you a project leader. Sorry, that's a little bit of a tough question to answer.
What are examples of area of settlement in the Schedule 2 exemption? What does that generally capture?
Good question again. Settlement areas are defined under the Municipal Act, and they basically are anything that's an urban or developed area. Something that wouldn't be considered a settlement area would be, crown land, like forested land, way outside of an urban area. And something like that could apply to maybe, larger infrastructure well beyond like maybe a transmission corridor where they have to move some excess soils on crown land where there is no historical activity, is basically virgin land. So a settlement area, there's a definition, and I think it's under the Municipal Act.
The next person wants to get a video recording. We did discuss this. You must have missed that very first part. The video recording will be available on our website in the next 2 or 3 days. Next question, how would this apply to excavated rock from a site?
Excavated rock, depending, again, excess soils has that definition in the reg that is very specific to, grain size and soil type. Excavated rock, depending on its characteristics, like if it's blast rock or large fragments of rock or boulders, if it's not soil, then it's not under the reg. However, if it is mixed in with soil, I think then you sort of err on the side of caution and you treat it as excess soil.
And one last question. Are there additional requirements for moving soil from a development that won't be reused, regardless of whether it's clean or not?
Sorry, could you repeat that, Carly?
Are there additional requirements for moving soil from a development if it won't be reused?
Again, the intent of the reg here, if you're moving soil from one property to another, it's got to be done in accordance with the soil rules. So you have to ensure that's being reused for a beneficial use. So I guess the answer to that question is no. I mean, like, you can't move excess soil to a property if it's not being beneficially reused. So there's the requirement of the reg is pretty explicit in that you have to be reusing the soil appropriately. You can't just take it to another property for end of life disposal.
And that was it for the questions. Thank you, everyone, for joining us. Just like to remind you, if you could take a few moments just to scan in that QR code. We'd love to hear your feedback on today's presentation.
Awesome. Thanks, everybody.
Thank you.